Hi, welcome to our live Q&A with California attorney Chris Fontala. How are you doing, Chris?
Good. How you doing, Tate?
I'm doing great, thanks. That's Chris. My name is Tate Lounsbury with mycourtcoach.com. And here we are. We're going to talk about some family law issues in California. Now, just a reminder, as always, what you're hearing here tonight is not legal advice. That's not what we're offering. We're just offering some of our own thoughts on questions that are posed by commenters on videos that are posted on YouTube. If you have some questions on a video that you've seen in one of our videos, go ahead and post a comment. We'll take a look at it, and then we'll address it on one of these live streams that we do Tuesday nights, 6 o'clock. Also, check out our website, mycourtcoach.com. There's a ton of information there, templates, videos, tools, guides on what to do in court, all sorts of helpful information, all for free. And if you need a little more help, we do offer a monthly subscription plan of $50 a month for some legal coaching, very much like the coaching, the discussions that we have on this live stream. Okay, so let's get to our questions. Let's start with, should we start with the first one? Let's start with this one. We have a question about subpoenas, and let me share this on the screen here. Give me a second. Okay, I believe it's shared now. Let's see if we can see it. Okay, so the question here is about subpoenas, and the question says, I sent a discovery request form for bank and credit card statements. This is a conservatorship issue that this person is dealing with. And the question is, what subpoena form to use for bank statements and credit card statements? Should he use the subpoena -002 form or something else?
And the answer to that is it depends. I'm assuming we're talking about California. That's a California form. And in California, whether you're talking about civil court, probate court, family court, they're all governed by the Civil Discovery Act. So it's basically the same thing for all of them. Now, the form that he specifically refers to, the SUBP-002, would be to have somebody appear at a hearing. I'm not sure if that's what he wanted to do. Generally, I would send out a deposition subpoena to get a hold of documents and records ahead of the hearing so that you can take a look at them. And that would be a different form. And of course, you'd also have to give the notice forms that go along with it. But the form that he's referring to, the SUBP-002, would work if you were going to have them show up at a trial. And assuming that they were properly served and that they are located in the state of California, they were required to appear at the hearing. And what you do when they don't show up at the hearing is you ask the judge to hold them in direct contempt of court and to issue a writ of attachment for their arrest. You do have to show up when you get served with a subpoena in California. Now, I'm not sure whether or not the police would honor that writ of attachment. Given the whole craziness that we have going on with the pandemic and stuff, I don't know whether or not they would actually arrest them and take them to court. But before the pandemic, that would be something that they would do. And then they would show up in court and the judge would then make arrangements for them to testify at the next hearing or whatever it is that made sense in the given case. I don't know what part of the proceeding this guy's in. I don't know if it was a hearing that had live testimony or whether it was just some kind of a hearing that involved a petition, which is normally done based upon the pleadings. So it's hard to say what the guy was doing. It sounds like he really needs some help from somebody that does conservatorships.
Now you'd mentioned notices. So if you send out a subpoena for bank records which are not your own, they're someone else's bank accounts, you need to send the notice to the consumer. Wouldn't that be reason for a hearing, or would that not be a reason to have a hearing? Because the judge is going to have to take a look at it. Will the judge do that in a hearing, or?
Well, there's two types of subpoenas. One would be the subpoena that he's listed here, which would be to show up at the hearing itself. And you don't have to do any other notice besides that. So that would actually be easier, but it does require that the court is planning on taking live testimony, which generally speaking in probate courts, they don't. I mean, unless they set it for an actual trial. Probate court's a lot like family court, where there's most of the hearings that they deal with are dealt with based upon written pleadings and arguments made by the attorneys. Sometimes they do set trials to deal with issues that can't be resolved that way. And, it's not as common as the other type, but assuming it's a hearing or a trial that involves live testimony, yeah, you can issue that subpoena and have that person show up and bring the documents that you're asking for, assuming they have them or have access to them. The court would require them to bring them. Now, the other way to do it would be the subpoena method, or for the deposition subpoena method, I should say. And, if they then fail to respond to that, you would then file a motion to compel. But that takes a lot of time.
You're talking about probate court because this person is asking specifically about a conservatorship case.
Yes.
So when he's sending the subpoena SUBP-002, does that get sent to the bank or to an individual whose bank account it is?
Well, you could do either, but based upon what he has in his question, it seems like he was trying to compel his siblings to show up and bring these bank statements with them. You could also do something similar, forcing the bank to provide statements, but we almost always do that with a deposition subpoena for documents because the banks don't want to show up. They're more than happy to look at your subpoena and say, yep, here's your documents and here's a declaration under penalty of perjury that these are true and correct documents. Thank you very much, and you owe us whatever for producing the records. The banks, they don't want to be involved in having to show up in probate court or family court or anything else for that matter.
Right. So if you're going to send it directly to the bank, you would not use this form. You would use what form?
The deposition subpoena form, along with the notice to consumer.
Okay. And you don't need the notice to consumer if you're just sending this particular form directly to the individual who holds the account?
Correct. Well, yes. And the deposition subpoena is the form number SUBP-010.
Very good.
And the notice to consumer is SUBP-025.
025.
Uh-huh.
And for all those listeners out there, strongly recommend you take a look at our YouTube channel. Go to our channel and look at the playlists, and you'll see videos on each of those different subpoenas. You can do a search for those forms that Chris just mentioned. Do a search on our channel, and you'll find the video that addresses each of those forms, that talks about how to use those forms. Okay, excellent. Thanks, Chris. I think that does a pretty good job of answering that question. What do you think? Anything else to add there?
Yeah, the only thing I would point out is that if you're trying to get records from a bank that's not located in California, you are going to have to pay attention to the law where the bank is located. Um, Usually that's not so much of a problem for banks because if somebody lives in California, then the bank is located in California. But for credit cards and for people that don't live in California, you actually have to subpoena them according to the laws of the state wherever the bank is located. And they're all different.
Yeah, I think we actually have some videos on that issue as well, on how to get people from a different state into court. So take a look at that as well. Okay, let's look at another comment, another question. I think this is the next one. This is from the same individual, actually, who asked the last question on the other comment on that other video. He says, so I can subpoena the bank and credit card company for statements. Can I use the SUBP-002 form to get those statements? If not, what form do I need? And I think you already just answered that question.
Yeah, I think we did.
Yeah, okay. All right, let's go to another one. Let me pull this up here. This question is about child custody and child visitation on a holiday, and how to get 50-50 custody split or visitation split for a holiday. This person says, how would I write a 50-50 split for a holiday? For example, mom gets kid the first half of the day and dad gets the later half of the day.
Sounds good to me.
What times are standard for 50-50? I'm having trouble finding out the time dad would have the child.
Yeah, there are no standard times in California. To the extent that the court can accommodate the parents so that the child has access to both parents on Christmas Day or whatever makes sense, the court will try and do so. Frequently, you'll see like 1 year in the even years, dad will get Christmas Eve and mom will get Christmas Day. And then in the odd years, it flips where mom gets Christmas Eve and dad gets Christmas Day. Actually, splitting Christmas Day in half may or may not work. I mean, it really depends on what's going on. If the parents live in the same neighborhood, it's a whole lot easier than if they're 2 or 3 hours apart. And so the parents, if they're agreeing on something, can literally write anything in that agreement that makes sense for them. And as long as the court understands what they're trying to say, they're going to approve that agreement. If that doesn't happen, the parents would then have to go to family court services and meet with the social worker. And the social worker, who has, of course, done this thousands of times, would have a lot of good ideas on how to approach that and explore those issues with the parents to figure out, how to best do it. But I commonly see, like what I said before, with one parent for Christmas Eve, and then the other parent will pick the child up in the morning at 8 a.m. or 10 a.m. or whatever they agree to. And then that second parent would then have the rest of Christmas Day with the child. And so it just depends. I mean, kids want to spend time with both parents on that holiday, especially when it comes time to opening presents. So whatever the parents can do to accommodate that is a good thing.
Yeah. Yeah, there's so much that depends. It's so fact specific. How far away do the parents live from each other? Are they 5 minutes or 5 hours? And yeah. Okay. We have a question here on our live stream. How can I subpoena a police report for petitioner prior to filing for divorce? X called and made a false report with LAPD, Los Angeles Police Department. Not sure who the petitioner is.
Well, generally speaking, if the person who wants to get a hold of the report is somehow involved in the report, the police department's going to have some kind of way to allow them to get it. If you have an incident where it's not been referred to the district attorney for prosecution, generally speaking, those reports can be had, and you would just get a hold of the Los Angeles Police Department, and they would direct you to the website that says, here's the process, send us a check or whatever they need to do to get a copy of that police report. Now, the police report might be redacted depending on whether there were statements from other parties. It depends on what they're doing. And
Yeah,
the
yeah, this is what
petitioner is the defendant.
yeah, that's what I was wondering.
So
If
is the person trying to subpoena the other party, or is the person trying to subpoena the defendant?
so typically here's what happens with the police reports is if, let's say there's one parent who is the person who was accused of a crime, the offending parent. Well, the child and the protective parent of the child, they'll be able to just go to the LAPD and say, hey, can I get a copy of the report? And typically they're just going to give it to them. But the person who is accused, the person who is being investigated, typically LAPD or the law enforcement is not going to give a copy of the police report to that individual, to the potential defendant, or to the actual defendant if there is a criminal case ongoing already. So that's why I think he's saying, or she is saying, asking about a subpoena, because they probably were already denied this informal process of getting the police report, so they need recourse to by way of subpoena. And this person is saying the DA declined to bring charges. So typically you would not, if you were the protective party or protective parent, you wouldn't need a subpoena. Now this person is saying, can I get the police report via a subpoena before the filing of a divorce? So there's apparently no court case. If there's no court case, can you use a subpoena process?
No. And the other problem you're going to have is the defendant, if they haven't been charged, the DA may never release those. It's up to the DA as to whether or not they want to release those and whether the police department wants to release those. The only thing you can do is contact them and ask them nicely. And if they say no, those reports are protected under government code and might or might not be reachable.
Yeah, so for this individual, as you're listening, we have a video specifically on this issue. It's one of the last videos that we did. You find it on a playlist. We have a video about getting juvenile court records, and we have a video about, pretty sure we have a video about getting police records. But the answer, I think, is going to be if you don't have a court case, not a restraining order, not a divorce, you're up a creek. Because your question is you want to get this prior to filing for divorce. You might have to just go ahead and file for divorce and then follow the procedures that we talk about in this other video about getting the police records. There is a form you could file in juvenile court where you are requesting access to police records. It's not in family court, it's a juvenile court, but we do have videos on that. So, okay. Great. She says she loves our channel. That's excellent. I'm happy to hear that. Thank you. Any other comments about that, Chris?
No, that thinking about it a little bit, I mean, when it comes to getting car accident reports, I mean, it's just routine. We get them all the time. When you're dealing with somebody that's possibly going to be charged with a crime, that's when sometimes it gets difficult to get your hands on these things. But it never hurts to ask, because maybe they'll do it.
Yeah, that is true. I've seen it where an individual who was accused was able to get those records without a subpoena. That was a long time ago.
Well, and it's, they might have to ask the detective handling the case whether or not they want to release it, and the detective may have looked at this and said, no, this is BS. I'm absolutely going to give it to this parent because the person that made these claims were full of baloney.
Yeah, it sounds like in this case they actually forward the case along to the DA's office, which often cops will do that even if they don't think there's much of a case there anyway, just to cover their own, for liability's sake, cover their own backside. Okay, that is all the questions we have, all the comments we have to review today. And thank you so much, Chris. Your help,
You're welcome.
as always. You're the best. You're great at this. And anyone out there can find Chris by just doing a Google search with his name, Chris Funtal. So thanks once again. Reminder to anyone out there, if you want access to all the other, in addition to the videos, access to all the other guides that we have, the how-to guides, the templates, everything else, which is just a lot of stuff. Register at our website, mycourtcoach.com. And I think that's all we have for now. We'll see you next week. Over and out.
Okay, bye.
Bye.